If your practice serves California patients, HIPAA is not the whole privacy story. California also has the Confidentiality of Medical Information Act, or CMIA. And in several key areas, CMIA is the stricter rule. Here is the simplest way to think about it. HIPAA is the federal floor. CMIA often raises the bar. So when the two overlap, California practices usually have to follow the tighter standard. Why does that matter? Because HIPAA is mainly enforced by the government. CMIA can also be enforced by patients themselves. In plain English, a privacy mistake can turn into a direct lawsuit. That one feature makes California risk feel very different. CMIA applies to healthcare providers, health plans, and contractors handling medical information for them. It can also reach out-of-state telehealth providers if the patient is in California. The law follows the California patient, not just the office address. CMIA also protects a broader category of data. HIPAA focuses on protected health information inside the traditional healthcare system. CMIA uses the term medical information. That broader framing can pull in more health-related data tied to a person's condition, history, or treatment. So if data clearly reveals something medical about a California patient, do not assume HIPAA is the only rule that matters. The next big difference is authorization. Under CMIA, authorization has to be specific. It must say who can disclose the information, what information will be disclosed, who will receive it, why it is being shared, and when the permission ends. It must also tell the patient they can refuse to sign without affecting treatment and that they can inspect and copy the information. That means broad, generic forms are risky. Any and all records may sound efficient, but it can be too vague. Combining treatment consent with disclosure authorization can also create problems. And marketing usually needs its own separate written authorization. A quick example makes this real. Imagine a telehealth practice using one standard HIPAA release form in every state. A California patient signs it. The team later shares records with a third party based on broad language in that form. Under HIPAA, the team may think the paperwork is fine. Under CMIA, that same form may be missing required elements or be too open-ended to hold up. Same workflow, different legal exposure. Breach response is another place where California moves faster. If a breach affects 500 or more California residents, notice to the California Attorney General is required within 15 business days. HIPAA's federal timeline is longer. So a response plan built only around HIPAA can leave a practice behind before it even starts. CMIA also gets especially sensitive around mental health records, substance use treatment, reproductive health information, genetic data, and some records involving minors. In those cases, the question is not just, can we share this? It is, do we have the exact legal basis to share it with this person for this purpose right now? So what should a practice do? Start with 4 moves. First, review every authorization form for specificity. Second, train staff on where CMIA is stricter than HIPAA. Third, make sure employer or HR medical records are kept separate from clinical workflows if your organization handles both. And fourth, update incident response plans to include California deadlines and notification requirements. The most common mistake is assuming HIPAA compliance automatically covers California. It does not. For California patients, CMIA is often the sharper rule, the faster rule, and the more lawsuit-driven rule. The good news is that CMIA becomes much easier to remember when you reduce it to 4 ideas. Specific authorization, broader medical information, faster breach action, direct lawsuit risk. If your team remembers those 4 points, the rest of the law starts to fall into place. So here is the takeaway. If you treat California patients, do not ask only, are we HIPAA compliant? Ask, would this hold up under CMIA? That is the mindset that protects patients, strengthens workflows, and reduces legal risk.